Lunch, if I can ask everyone to be seated. Scott? If everyone could take their seats, good afternoon. I hope you enjoyed the lunch. And we're very delighted to welcome you back. The only reason I'm up here is because Justice Lorenzetti was part of our panel. Where's my co-chair, Jay? So this is the last part of our panel. But we are both very pleased to introduce the video remarks of Ricardo Lorenzetti, the Chief Justice of Argentina. He's also the Organization of American States Goodwill Ambassador for Environmental Justice, and he's also on the interim governing committee of the Global Judicial Institute on the Environment. And did Jay want to make any remarks? Okay, with that, I think we're ready to start the video magically.
En este sentido, la idea de explicar y trabajar el concepto de Estado de Derecho Ambiental es central en la relación entre poderes judiciales y ambiente. La noción de Estado de Derecho históricamente está vinculada a la aplicación en poner un límite frente a las decisiones arbitrarias de los soberanos, de los presidentes o de los poderes fácticos que fueron trabajando durante casi todo el siglo XIX y XX. Luego, en nuestra región, principalmente en América Latina, adquirió un significado distinto o adicional cuando se comprendió que además de la ley, estaban los tratados internacionales y las constituciones que reconocían derechos fundamentales o derechos humanos. Entonces comenzamos a hablar de Estado constitucional de derecho, porque no se trataba solo de la ley, que es una expresión de las mayorías parlamentarias, y esas mayorías parlamentarias podían...
I apologize for the glitch with the interpretation. We are going to restart the video in order for you to have the full video in English. Thank you very much for your attention.
Por no poder estar presente y acompañarlos en esta reunión, lamentablemente por las actividades que tenemos hoy en la Corte Suprema no puedo asistir, pero desde ya cuentan todos ustedes con mi apoyo permanente. Mis saludos y felicitaciones a los... Expresar en primer lugar las disculpas por no poder estar presente y acompañarlos en esta reunión. Lamentablemente por las actividades que tenemos hoy en la Corte Suprema no puedo asistir, pero desde ya cuentan todos ustedes con mi apoyo permanente. Mis saludos y felicitaciones a los organizadores, a Claudia de Win, por el esfuerzo que pone siempre para convocarnos, a la Organización de Estados Americanos, a la UICN, a ONU Ambiente y al Instituto Judicial Mundial, que es un emprendimiento en el cual estamos todos involucrados porque creemos y estamos muy convencidos de la trascendencia que tiene para todos los poderes judiciales del mundo que tengamos una visión común, por lo menos en los aspectos fundamentales, en lo que hace a la relación entre los poderes judiciales y el ambiente. En este sentido, la idea de explicar y trabajar el concepto de Estado de Derecho Ambiental es central en la relación entre poderes judiciales y ambiente. La noción de Estado de Derecho históricamente está vinculada a la aplicación de la ley para todos en función a la igualdad frente a la ley. Ese significado histórico en gran medida tenía su razón en poner un límite frente a las decisiones arbitrarias de los soberanos, de los presidentes o de los poderes fácticos que fueron trabajando durante casi todo el siglo XIX y XX. Luego, en nuestra región, principalmente en América Latina, adquirió un significado distinto o adicional cuando se comprendió que además de la ley estaban los tratados internacionales y las constituciones que reconocían derechos fundamentales o derechos humanos. Entonces comenzamos a hablar de Estado constitucional de derecho, porque no se trataba solo de la ley, que es una expresión de las mayorías parlamentarias, y esas mayorías parlamentarias podían equivocarse, podían dictar leyes inconstitucionales, y entonces se comenzó a comparar la ley con la Constitución y los derechos fundamentales. Y entonces este Estado de Derecho constitucional tuvo un gran impulso durante todo el siglo XX, fundado en el reconocimiento que hicieron muchos poderes judiciales y cortes sobre la efectividad y la aplicación de los derechos fundamentales, principalmente los derechos económicos sociales. En el siglo XXI comenzamos a ver otro fenómeno, que es el funcionamiento del Estado de Derecho dentro de un nuevo paradigma ambiental, porque, como lo hemos dicho muchas veces y creo que todos los compartimos, estamos en una situación en la cual el ambiente está en un punto crítico y no es posible pensar las cuestiones jurídicas o los conflictos sin un paradigma ambiental. No se trata solo de una especialidad más del derecho, no se trata solo de un área específica de los poderes judiciales, no se trata solo de crear un tribunal ambiental o de una sentencia específicamente dedicada a cuestiones ambientales. Se trata de comprender de otra manera el funcionamiento del Estado de Derecho. ¿Qué significa esto en concreto? Nosotros siempre hemos trabajado sobre una cantidad de aspectos muy específicos que implican que apliquemos un mismo estándar, que es el histórico del Estado de Derecho, a las cuestiones ambientales. Y esto por dos razones. La primera es porque si hay doble estándar, se pierde la credibilidad en el Estado de Derecho. Si se aplica para una actividad o un caso los principios del Estado de Derecho y cuando se trata de cuestiones ambientales no se lo aplica, esto afecta la credibilidad. Y lo segundo es que es mucho más sencillo para los jueces acceder a las cuestiones ambientales aplicando precedentes históricamente fundados y no cuestiones novedosas que a veces son a la transparencia, a las reglas del buen gobierno, a la noción de gobierno abierto, que es algo muy aceptado en Naciones Unidas, está muy aceptado en casi todos los países y además está aplicado por los poderes judiciales. Es decir, hay acceso a la información, de la ciudadanía legislaciones. Estos tres aspectos, el programa de gobierno abierto de Naciones Unidas y muchas legislaciones que van implementando y los poderes judiciales lo hacen. Este criterio también debemos aplicarlo en el campo ambiental y muchas veces eso no sucede porque cuando se piden estudios de impacto ambiental, se pide información sobre los proyectos que puedan afectar al medio ambiente, hay resistencias, no se los quiere otorgar. Entonces, reconocer derechos de participación, derechos de transparencia informativa y acceso a la información es que es muy aceptada en los derechos fundamentales, en el campo de los derechos humanos, la idea de protección de la parte débil, tanto en el derecho público como de vulnerabilidad y necesita protección, hay resistencia a aplicar la protección que damos y reconocemos para los seres humanos a la naturaleza. Este doble estándar también debe ser solucionado y entonces decimos, si hay un principio de protección basado en la historia de los derechos fundamentales, en las constituciones y también en el derecho privado, desde la época en que el derecho romano reconoció el principio en favor de Vitoris, podemos también aplicar indubio pro natura, es decir, en caso de duda, protección de la naturaleza, es decir, eliminar esta idea de un doble estándar. Otro aspecto que también es muy importante se refiere a una tradición que tenemos en esta región y en muchas otras regiones sobre la progresividad de los derechos fundamentales o derechos humanos. En la región americana está reconocido esto en la Carta Interamericana y en decisiones de la Corte Interamericana y también de muchas cortes nacionales. Entonces, si nosotros decimos que los derechos fundamentales deben ser progresivos, es decir, evolucionar hacia una mayor protección, ¿por qué advertimos que en el campo ambiental hay una regresión? Entonces, este también es un doble estándar y podemos aplicar este concepto de progresividad de los derechos fundamentales en el campo ambiental. Y no es menor esta cuestión en el mundo actual, porque vemos que hay una regresión muy clara. Michel Prier habla del principio de no regresión, y tiene efectividad concreta porque hay casos y sentencias que dicen que una legislación que desmantela una protección ya consagrada en materia ambiental puede ser descalificada por un tribunal. Incluso en Argentina ya tenemos sentencias en el campo de los derechos sociales que establecen que el principio de progresividad puede autorizar a una corte a descalificar una ley inconstitucional por esa razón, porque es una regresión. Esto también se puede aplicar en el campo de los derechos ambientales. En fin, creo que hoy hay una cantidad de aspectos muy relevantes para trasladar desde la noción clásica del Estado de Derecho y todos los principios derivados de este Estado de Derecho a las cuestiones ambientales. Y en esto tienen un rol fundamental los poderes judiciales, porque lo que estamos viendo es que en función de los cambios que hoy existen en el mundo, muchos poderes ejecutivos y congresos o parlamentos están recibiendo demandas electorales muy inmediatas y reaccionan frente a estas demandas también con criterios de inmediatez, criterios electorales. Y entonces esto lleva a un retroceso en las cuestiones ambientales, básicamente porque esto implica costos fuertes, actuales, para beneficios futuros o muchas veces invisibles. Entonces ahí es donde están los poderes judiciales que tienen esta posibilidad, porque no están vinculados a esta estructura de incentivos institucionales electorales. Los poderes judiciales pueden imponer costos actuales para beneficios futuros. Y ahí es donde aparece un actor fundamental, que es el de las generaciones futuras y sus posibles representantes. Por ejemplo, en el principio de no regresión, la idea es trabajar sobre el concepto de capital mínimo trasladable de generación en generación. Es decir, que los poderes judiciales pueden establecer que una generación no puede disponer o tomar medidas que afecten un capital de recursos naturales o el funcionamiento del sistema que prive a las generaciones futuras del mismo goce. Es decir, hay una cantidad de aspectos importantísimos que no son discutidos en las decisiones inmediatas que tienen que tomar los poderes ejecutivos o las decisiones inmediatas que adoptan los parlamentos, pero que sí son materia de muchos casos y sentencias judiciales en los poderes que nosotros representamos. Entonces, el siglo XXI está claramente marcado por la cuestión ambiental y el rol de los poderes judiciales. Por eso celebro esta reunión y lamento nuevamente no poder estar presente para acompañarlos con tantos amigos y compañeros de ruta en estos ideales que nos llevan. Saludos para todos.
Sure, that's fine. Welcome to our panel on climate change, pollution, and judicial remedies. I'm Michael Gerard. I'm here with my colleague Durwood Zalke. We're going to be the moderators. Professor Zalke is going to say a few words, then I will, and then we will call on the three members of the panel to give their talks, and then we'll have a discussion. Durwood, start.
Thank you. If I were a young, are we on here? If I were a young lawyer, I would be applying for a job as a law clerk to one of the three justices up here so that I could make my mark on climate change. And I would try to impress these eminent justices with my understanding of the science to start with. And I would say that judges should start thinking of getting PhDs along with their JDs for their clerks to tackle the problems of climate change. And I would start by saying that climate change is not a problem for tomorrow, for intergenerational equity, as we started thinking about it, but it's a problem of today. We have warmed the planet 1 degree, and we are seeing impacts that we can barely tolerate. And I notice a hurricane building up outside of Hawaii right now. We are in an existential fight. What was once considered the fat tail of probability, the 5% at the extreme, has now moved to the median. We are in this fight now. And we are facing something that is a mismatch of timescales. So we have a fast-moving problem, indeed an accelerating problem, because of a series of positive self-reinforcing feedbacks, a series of dominoes that as we tip them over, they accelerate the warming. The most dangerous of these is underway right now. It's the loss of the reflectivity, the great white ice shield of the Arctic that sends a tremendous amount of heat back into space. We're losing it probably within the next 15 years. And what we lost up to 2011 added 25% as much warming as CO2, or carbon dioxide, the main climate pollutant. And when we lose it all, it will add perhaps twice as much warming as CO2 has added. Now think of that, within 15 years. That domino tips over, and it sets off the next one, which is the collapse of permafrost. I had the pleasure of living and litigating for many years up in Alaska back in the 80s. And the permafrost was indeed permanent frost, but when it melts, it releases a very powerful greenhouse gas called methane, as well as CO2. And then the boreal forest starts to collapse, and that loses a sink that sucks CO2 out of the atmosphere and puts it back in. So that wicked cascade is what we need to be focusing on now, within the next 15 years. We have solutions, and I just finished a report with 33 co-authors on how to stay well below 2 degrees. 2 degrees is too much. We're aiming for 1.5, remembering that we're already at 1 and facing impacts that are pretty devastating right now, and the 1 degree that we see has more following it that's already baked in to the system. The solutions come in 3 categories. One is clean energy and energy efficiency to get rid of CO2. We know that's a great thing that we have to do. But because when we reduce fossil fuel CO2, we also reduce co-emitted sulfates. And those sulfates are cooling the planet. So for the first 10 or maybe 20 years of reducing fossil fuel emissions, we get warming, not cooling. Okay? So if you're facing a 15-year window, you got to think this is not enough to save us. The second solution, or think of as a lever to pull, is how to reduce the short-lived climate pollutants. Black carbon soot, which is an air pollutant, methane, tropospheric ozone, lower atmosphere ozone, and HFCs, hydrofluorocarbons, which are refrigerant. We just took them out under the Kigali Amendment to the Montreal Protocol. That single act will avoid up to 0.5 degree of warming in the future. And if we make our air conditioners and cooling devices more efficient, we can get up to a full 1 degree from future warming. Very important. So that's the second lever, and that's the fast one. That gives you 2, maybe up to 6 times more avoided warming at mid-century than the CO2 lever does. So you got to do that one too. The third is to learn how to pull CO2 out of the atmosphere. Because we put a lot up there and it stays for a very long time. Up to 40% stays up to 500 years. So learning how to take it out is really important. Now we start with the brilliant technology of photosynthesis. And of course, we have a judge who has been saving his part of the Amazon with his effort to save the forest. We need to save the forest and expand forest wetlands, grasslands, because it's not just the biomass, but it's the carbon in the soil. Put it back in the soil where it can stay for a very long time. Those 3 things can perhaps get us to 1.5 degree if we are really aggressive. We may need geoengineering as well. Dangerous, and it will present questions for judges. Because if some country is threatening to shoot sulfate rockets into space to cool the planet. It will change rainfall patterns around the world. What will that do to someone else's agriculture? How will we manage that kind of risk? Judges will be called on for that. So this package of solutions needs to be speeded up, and that leads to the question of why are we going slow when we know the problem is so serious and we have so many solutions? So we look to the vested interest. Of course. I mean, it's, somebody is going to lose some money in the short run, but all of us have the chance of saving the planet in the long run. It's not even the long run now. So I will draw your attention just to one vested interest, which is the oil companies. And I happen to spend some time reviewing the Exxon new file that some of you may be familiar with, where this great oil company, descended from Standard Oil, the Rockefeller fortune, has now decided, and the Rockefeller family has decided, that they are unhappy with the performance of their original company and have funded a campaign to see why Exxon has been so bad. And when you look at the documents in the 1970s, you start by seeing brilliant science that Exxon was doing, peer-reviewed science, saying we can predict when we will hit 400 parts per million of CO2 in the atmosphere. They were spot on. And then you see them saying in their documents, which are all in the public record, saying we know that our product may cause catastrophic impacts. And when you read the documents, you think for a moment, what if? What if? And then they pivot in the 1980s to a campaign of doubt. And they hire many of the same people that the tobacco industry used for their campaign of doubt. And that effort, and they rounded up many other fossil fuel companies, has set back climate in the United States, more than any other country, but also around the world. I've been participating in the UNFCCC, the UN Framework Convention on Climate Change, since it was first put together. I helped organize a client group called AOSIS, the Alliance of Small Island States, many years ago, when I had first started a group called the Center for International Environmental Law. And when you, and I'm going to end in just a moment, but when you look at that, we're COP22 now, I think, you look at the dance that we've done around the world. That dance has been orchestrated as much by fossil fuel companies as anyone. And it's been a brilliant effort to keep negotiators and scientists waltzing slowly, slowly, slowly around the world until at Paris, which we consider an accomplishment, we got what at the end of the dance? We got a kiss on the cheek, okay? We got a voluntary agreement that says we're all going to try. Okay, that's not enough. So if we want to save civilization, we need the rule of law to kick in through the judiciary in a way that it has perhaps never done. Thank you.
About the status of U.S. climate change litigation. Our center at Columbia maintains a website that tries to keep track of all of the climate change related litigation around the world. And there is far more climate litigation in the United States than in the rest of the world combined. We're a very litigious country. We've counted more than 800 lawsuits that have been brought on climate change in the U.S. The most interesting ones that are happening today, I think, fall into three categories. The first category is lawsuits that are challenging the efforts by the Trump administration to repeal many of the climate-related and other environmental regulations that were enacted before. Every action that the Trump administration is taking, once it is ripe, is being challenged in court by environmental groups and by the states that support climate regulation. This is not a new phenomenon. When Barack Obama was president, everything he tried to do was challenged in court by industry and by the states that oppose climate regulation. But many of these lawsuits challenging the Trump administration have been successful, mostly because the administration has not been very careful in following the necessary administrative procedures in going about its deconstruction of environmental regulation. So this litigation will continue. The second category are the lawsuits that have been brought by, there are a total of 11 lawsuits brought by cities and counties and one state, Rhode Island, against the fossil fuel companies for damages caused by climate change. All of these lawsuits are seeking money, either damages or the cost of adapting to climate change, building seawalls or that kind of thing. All of them are brought under the common law doctrine of public nuisance. Several other theories are also brought in several of them. Quite a few of the lawsuits talk about the campaign that Professor Zelke just described by the oil companies or some of them to deny climate change. There was another round of very similar litigation in the US 10 years ago, culminating in a decision from the United States Supreme Court in 2011 called American Electric Power versus Connecticut. In that case, the Supreme Court held that the federal common law of nuisance cannot be applied in the climate change context because Congress, when it enacted the Clean Air Act in 1970, gave EPA the exclusive power to regulate greenhouse gas emissions, and it was not for federal judges to do that under the federal common law. So these new lawsuits are being brought under the state common law of nuisance. Several of the defendants are trying to get these put into federal court. So far, of the 11 lawsuits that have been brought, 2 have been dismissed, and the others are pending with a great deal of motion practice pending on them. The third category of very interesting cases are brought under the old public trust doctrine. There's an NGO in Oregon called Our Children's Trust, which has been organizing several of these cases. Most of them have been dismissed, but one of them has survived. It's called Juliana versus United States. It's pending in the U.S. Federal District Court in Oregon. And in that case, 2 days after the election of President Trump, the district court denied a motion to dismiss by the federal government and found that the common law, that the public trust doctrine may well apply to this lawsuit brought by a group of young people who are saying that their generation is endangered by climate change. The district court also said that the public trust doctrine is embodied in substantive due process under the United States Constitution, which was a holding that surprised some of us. But then the 2 months later, shortly before President Trump was inaugurated, the U.S. Department of Justice, still under President Obama, answered the complaint and admitted many of the allegations in the complaint. It admitted the reality of climate change and the role of humans in causing it and the terrible consequences that it will have. Ever since then, the Department of Justice has been trying to get rid of the case. They've gone up to the U.S. Court of Appeals for the Ninth Circuit twice and the U.S. Supreme Court once without success. The district court has set a trial date of October 29. So it appears that the defendant, United States government, has exhausted its ways of trying to prevent that trial from happening. The plaintiffs are saying it will be the trial of the century. We will see. But the plaintiffs are asking for an order that the federal government come up with a plan to radically reduce greenhouse gas emissions and then be required to implement that plan. So it's going to be very interesting to see how that case plays out. I cannot tell you that I am optimistic that the case would survive its ultimate review before the United States Supreme Court as it is now constituted, but it's going to be very interesting to see this case as it proceeds. So those are, I think, the three most interesting areas of climate change litigation happening in the United States. And what I would like to do now is to call upon Justice Michelle Weeks of the High Court of Barbados to give remarks.
Good afternoon, everyone. I first wish to thank the organizers for inviting me to attend and to speak at this symposium. I think it speaks volumes that coming from a small country like Barbados, we are only 166 square miles, less than 300,000 people, that I am here to articulate Barbados's position and to some extent the Caribbean's position with respect to the topic relating to judicial remedies. It is almost trite to say that the Earth's environment impacts every area of our lives. As a result, global warming caused by pollution with resulting climate change have the capacity, as you've heard just now, to change Earth forever if unchecked. This reality has been recognized by the United Nations climate change regime, starting with the United Nations Framework Convention on Climate Change, continuing with the Kyoto Protocol, and culminating with the Paris Agreement. In the context of growing concerns related to climate change and pollution, the judiciary has a critical role to play as protector of the environment and cannot be seen to shirk its responsibilities in defense of the earth. The development of related jurisprudence is therefore vital. While the judiciary's role is important, a judge may only rule on matters brought by legitimate parties. The development of climate change jurisprudence is therefore fostered by the expansion of the categories of persons and entities which have standing in relation to the climate change issues. Legal standing varies within jurisdictions, but it is usually tied to whether the party has an interest to the extent that they are personally affected by an occurrence. From critical observation, it may be possible to identify a wrong being perpetrated on the environment. However, identifying the necessary contributory elements can sometimes be a complicated task. Since the Paris Agreement, there has been an explosion of climate litigation, particularly in the USA, Europe, and other countries around the world. The Urgenda Foundation and Kingdom of the Netherlands is a case which illustrates how pollution and climate change are inextricably linked. A class action lawsuit brought by 886 Dutch citizens represented by an NGO against the Dutch state in 2015. And in that case, the plaintiffs claimed that the discrepancy between the Netherlands mitigation target and what the IPCC considers necessary to prevent harmful climate change amounts to a violation of the state's duty of care to its citizens. The court accepted the claim, and the plaintiffs obtained relief, commanding the Dutch government to adopt a more ambitious mitigation target, determining that the Dutch government must reduce CO2 emissions by a minimum of 25% by 2020 to fulfill its obligation to protect and improve the living environment against the imminent danger caused by climate change. There have been further cases as well. In the case of Ligari and Federation of Pakistan, a farmer challenged the government's inaction in climate policy, claiming a violation of fundamental rights. The court agreed and ordered the government to constitute a climate change commission and to adopt more ambitious adaptation measures. In addition, there's the Vienna Airport expansion case, VZW and Kingdom of Belgium, the Union of Swiss Senior Women case, the Greenpeace Nordic Association case, as you would have just heard, the Juliana and United States case, and a 2016 Colombian case, among many others. And for a more detailed and complex review of climate change litigation, I commend to you a UNEP document, The Status of Climate Change Litigation, a global review which was prepared in conjunction with the Sabin Center for Climate Change Law. These cases are all relevant. For the most part, they involve citizens taking a stand against their governments. Now to some general observations about small island developing states, which are signatories to the Paris Agreement. As such, we too have pledged to do our part with respect to the reduction of carbon emissions and also move towards more sustainable development. But the problems created by climate change have not been created by these small countries, countries which already face serious financial challenges. And it is noteworthy that most of the climate change litigation cases are not from small jurisdictions. The Caribbean generally experiences problems accessing climate financing. This is despite the fact that the Caribbean is recognized as the second most climate vulnerable region in the world. There are problems accessing these funds due to a focus on per capita income. The criteria for funding perhaps needs to be re-examined. I am aware that diplomatic efforts continue with respect to easier access for funding for climate change projects. There are also several serious climate change issues which face the Caribbean and other small countries. There's sea level rise, also the destruction wrought by hurricanes, the impact of the sargassum seaweed on these already struggling economies. There's also the problem of reduced agricultural yields and reduced access to water resources due to decreased precipitation. These issues are all attributable to climate change, according to the scientists. The question may be asked, who would have standing in a potential lawsuit in respect of either of these cases? Should the citizenry reasonably sue their government for a problem not initiated within the jurisdiction? If not, who should they sue? I ask this question with the full knowledge that smaller countries have also made commitments to the various protocols on climate change. It may be argued that the developed countries are the ones who created the problem. And if they did, would the less financially able smaller countries have the financial wherewithal to sue the bigger countries? I hasten to add that despite my concerns, I am hopeful that the guidance provided in the Oslo Principles on Global Climate Change Obligations may not only help judges decide whether governments are complying with their legal obligations with respect to climate change, but strengthen the bargaining position of poorer countries by pointing to the far-reaching obligations of wealthier countries. In addition, I am also aware that diplomatic efforts continue with respect to easier access to climate funding in the Caribbean. Now, scarcity of resources is one of the known triggers of conflict. Climate change affects livelihoods in penetrating ways, which have a direct effect on poverty and job opportunity. With these key aspects of social stability in flux, people may become unsettled, and then there may be breeding environments of hostility and violence. In areas where there is a significant negative impact of climate change as a result of challenges, for example, desertification, food and water supply, may become significantly limited. The management and preservation of resources, therefore, must be one of the primary functions of the court in its contribution to the safety of states affected. Within the Caribbean region, this is of course a priority as the effect of hurricanes and earthquakes greatly damage small islands with small economies. The court must therefore find ways to facilitate preservation to prevent unmanageable scarcity and also function efficiently in the process of rebuilding by applying legislation in practical ways to facilitate onward development. Recently, Professor Gerard has written an article exploring the possible impact of migration caused by climate change resulting in human trafficking. And Barbados, together with other Caribbean islands, have also recognized the security implications for the region. Just last year, Barbados tabled a resolution on the security implications of climate change at the OAS, and that resolution was adopted at the 47th General Assembly held in June 2017. That diplomatic work also continues. And with respect to intergenerational equity, Article 3 of the UN Framework Convention on Climate Change recognizes the generational nature of climate change. Climate change jurisprudence requires a judge to not only consider the present injury, but to cast his or her mind towards the future. There's a recognition that present actions have the potential to impact subsequent generations. Simply put, it is fairness between generations. A number of principles must be employed in determining the necessary balancing act which courts must engage in. Firstly, the court must consider comparable options, which requires conserving the diversity of the natural resource base so that future generations can use it to satisfy their own values. Secondly, the court must ensure comparable quality, ensuring that the quality of the environment is comparable between generations. And thirdly, the court must ensure comparable access, which means non-discriminatory access among generations to the earth. Those are just a few of my thoughts on the topic at hand. In conclusion, it is without question that the court is the repository of justice for the inhabitants of the globe. In protecting its citizens, the court must also provide an extended protection for the world in which we live. We must ensure that generations to come have an equal standard of life, particularly where that can be facilitated by present actions. We must therefore be willing to move the lines of current norms and bravely protect the already conquered frontier that is our home.
I'd like to now call on Justice Luis Armando Tolosa of the Supreme Court of Colombia.
Buenas tardes para todos ustedes. Mi nombre, Luis Armando Tolosa Villabona. Muchas gracias aquí a la mesa, quienes están presentes. Fundamentalmente quiero agradecer a la doctora Claudia Wynn, los organizadores del evento, el doctor Scott Fulton, Michael Wilson, aquí a mi izquierda, Denis Antolini, Arnold Krulher y Antonio Benjamín, organizadores del evento, y yo, por supuesto, a las organizaciones que han puesto la bandera para este evento, a la OEA, Unión Internacional importante de los Estados Americanos para la Conservación de la Naturaleza, la Comisión Mundial de Derecho Ambiental, el Programa del Medio Ambiente de las Naciones Unidas, los jueces de la Unión Europea para el Medio Ambiente, el Instituto Global Judicial para el Ambiente, al Instituto de Derecho Ambiental, y se encuentra aquí presente, gracias por la asistencia, el delegado de negocios de la República de Colombia, el doctor Álvaro Calderón, y la señorita Luisa Ferreira. Muchas gracias por la asistencia. Bien, para mí, como integrante de la Corte Suprema de Justicia de la República de Colombia, el tribunal más antiguo de mi país, y para la Corte de que formo parte, es muy grato estar en este escenario, sí, para exponer algunas ideas que son relevantes en la construcción de un mundo incluyente y que resultan determinantes, sobre todo por las afugias ante el cambio climático, la contaminación, la destrucción del universo. Me convocan aquí la invitación para que exponga algunas ideas sobre lo que significa, cuál es la incidencia judicial del cambio climático, la contaminación y los recursos judiciales. Bien, para avanzar rápidamente en los minutos que se me otorgan, quiero señalar en primer lugar cuál es la acción idónea que tenemos para proteger los derechos fundamentales y la construcción de una democracia ambiental como supuesto para el nuevo Estado de Derecho. Necesitamos auscultar los ordenamientos nuestros, porque es probable que no haya una legislación sobre el particular concreta. Entonces necesitamos acudir a los principios, a los valores y derechos para buscar, si no tenemos una acción expresa, un medio subsidiario de la lucha contra los fenómenos que en forma inminente están atentando contra la supervivencia de la humanidad. Bien, en nuestro país, ¿sí? Ustedes saben que es un país convulsionado, ¿sí? Con violencia política, paramilitar, guerrillera, de derecha, de izquierda. Estamos en tránsito de un proceso de paz. La presencia paramilitar, ¿sí? Paraestado de alguna manera, ¿sí? Los conflictos y las brechas económicas ha generado la necesidad de incentivar reformas políticas y reformas legales. Pues bien, en 1991 se expidió una Constitución de 1991 que trata de ser inclusiva y trata de acercarse a la solución de los problemas. Allí, dentro de los recursos judiciales se incluyeron algunas acciones que debo señalarles de importancia, como son la acción de tutela, la acción de grupo, acciones populares, acción de inconstitucionalidad. También tenemos los recursos que están en las leyes ordinarias que tenemos en los diferentes países, los códigos de procedimiento civil, toda esa serie de procesos declarativos. Pero ¿cuál es la importancia, cuál es el medio idóneo que hemos encontrado nosotros los jueces y la ciudadanía en general para trasladar la solución de los problemas, la acción de tutela? De alguna manera ha entrado en conflicto con las acciones populares. ¿Qué significan estas acciones? La acción de tutela es un mecanismo que existe para la protección de los derechos individuales y las acciones de grupo para los derechos colectivos. Cierta tendencia considera que la protección de los derechos fundamentales tiene que darse por vía de las acciones colectivas, las acciones populares, las acciones de grupo. Consideramos que la acción de tutela es el medio idóneo porque permite en 10 días resolver una situación en primera instancia, en 20 días la segunda instancia, pero además consideramos que a través de ella podemos proteger derechos colectivos. Da una legitimación universal para que todos los ciudadanos afectados sin necesidad de abogado, sin necesidad de derecho a postulación, puedan ejercer directamente. Bien, esta acción ha permitido entonces que se trasladen al escenario las más diversas controversias de género, controversias de censura de prensa, controversias políticas, de todo orden, de situado fiscal, controversias de la familia, controversias de violencia intrafamiliar. Allí han llegado a través de esta acción los problemas del medio ambiente. Estas acciones nos han permitido crear una estructura jurídica sobre la que creemos, una concepción sobre la que podemos edificar las acciones de protección de los derechos fundamentales ligados con el medio ambiente. En primer lugar, nos han permitido formular un nuevo paradigma, demostrar que los jueces tenemos que trabajar sobre este paradigma en Colombia del tránsito de una visión antropocéntrica, donde el hombre es el centro de todo, a una visión ecocéntrica antrópica, que haya un diálogo entre la naturaleza y el hombre esté en pie de igualdad, y no el hombre, persona natural o jurídica, o las instituciones, ¿sí? minusvalorando la naturaleza. Y entonces creemos que esta visión permite ponernos en pie de igualdad, en diálogo dinámico con la naturaleza. y de esa manera proteger y ver como iguales a la naturaleza. El otro aspecto que resulta relevante destacar a propósito de esta visión ecocéntrica antrópica, donde estaremos lo antrópico, el hombre como tal dialoga, construye y legitima la naturaleza. Esta visión tiene que edificarse en un orden público ecológico mundial y nacional, teniendo en cuenta la cantidad de principios, precaución, prevención, gobernanza ambiental, teniendo en cuenta también ideas centrales como la responsabilidad ambiental, ¿sí?, la soberanía ambiental y el respeto a la decisión de los pueblos, la consulta, en fin, para que construyamos una democracia ambiental. Un tema central aquí en la reformulación y la protección es considerar a la naturaleza, a los seres vivientes, como sujetos de derecho. Nosotros tenemos que reformular un concepto que tenemos al interior del derecho, y es que la naturaleza, los seres vivientes son sujetos de derecho y por lo tanto titulares de derecho, y todos nosotros somos los representantes, los cuidadores. Y en ese sentido no se puede reclamar, no le podemos reclamar que tengan deberes, porque en consecuencia tendríamos que decir que los impúberes, ¿sí?, o los discapacitados mentales no serían sujetos de derecho, y también las personas jurídicas que son entelequias, ¿sí?, entelequias mentales. Bien, ese concepto de sujeto de derecho debe reformularse. También hay que abordar seriamente la idea de justicia climática y de la autonomía y la independencia judicial. Y el otro aspecto que necesitamos defender y extraído a partir de los principios tiene que ver con los derechos fundamentales intergeneracionales, es decir, las futuras generaciones tienen derechos fundamentales. Bien, estas ideas las hemos construido a partir de los casos que nos han llegado. Algunos de los casos relevantes que nos han llegado han tenido relación con el transporte de carbón frente a la contaminación de ríos, frente a primates que han sido seleccionados para hacer investigaciones, por ejemplo, contra la fiebre amarilla en inmunología, ¿sí?, de cómo cazarlos y para utilizarlos en estos experimentos, en fin, y la decisión del río Atrato. Hay dos decisiones en las que he sido ponente y donde están expuestas estas ideas, y tiene que ver la primera decisión con la defensa de la Amazonía y la declaración de la Amazonía colombiana como auténtico sujeto de derechos. Y otra decisión que se encuentra en el mismo contexto tiene que ver con la problemática que se suscitó con un oso de anteojos, un ser sintiente nacional, emblema, que se encontraba con una ocesna en una zona fría de los Andes colombianos, cerca de la ciudad de Manizales, y mediante un acto administrativo fue trasladado al zoológico de Barranquilla a 0 grados de altitud junto al mar. Y estos osos andinos entenderán ustedes que se encuentran en los Andes colombianos. Y aquí entonces un ciudadano promovió, al ser llevado al cautiverio, estaba en un semicautiverio, a un zoológico, pues la decisión llegó a la Corte Suprema negada. Yo fui el ponente de la decisión y tuve la oportunidad de plantear el problema de si podrían ser titulares el oso del derecho fundamental a la libertad. No es tanto el problema por si tenga o no derecho a la libertad. El problema, una de las tesis que teníamos que defender es que nos encontramos en un tránsito de una misión, de una mansión, de un concepto de mundo antropocéntrico, donde el hombre, je pense dans je suis, porque pienso, existo, o digamos, viendo desde la postura de Renato Descartes, sí, porque yo pienso, de lo único que no puedo dudar es de qué pienso, y entonces el hombre lo es todo, digamos, la visión del renacimiento, del hombre que conquista. Aquí pudimos defender esa visión y se encuentran esas decisiones, y el oso como sujeto de derecho, obviamente que los que correspondan, no para que haga parlamentos y discuta con ellos, porque pues sería, es decir, cómo el sujeto de derechos oso, ¿sí?, forma parte del ambiente, la fauna y la flora, los seres bióticos y abióticos. Y entonces, como parte integrante, necesitamos trabajar en esa línea para reconstruir. Esa acción del habeas corpus, donde expusimos estas ideas centrales que tenemos aquí, estos principios básicos, nuevamente pudimos replantearla en la tutela de la Amazonía, y en esta tutela de la Amazonía, pues, por ejemplo, el tema intergeneracional. ¿Por qué aparece allí el tema? Dimos una orden concreta para proteger contra el cambio climático. Tutelamos el tema o amparamos la protección frente al cambio climático y amparamos igualmente los derechos de las futuras generaciones. Uno, porque los accionantes eran niños de 7 a 15 a 25 niños y algunas personas que entraron en la mayoría de los 25 años, más de 25 accionantes. Entonces ellos van a tener su adultez en el 2040, en el 2050, y otro, la vejez, hacia el 2070. Entonces ellos reclamaban contra la creciente deforestación. Colombia se adhirió al Acuerdo de París del 2015 y se comprometió a reducir la deforestación a grado cero. La destrucción que hay de la Amazonía es enorme. Convocamos a los países integrantes en la Amazonía para que a través de sus jueces, ¿sí?, adelanten acciones, auscultemos la Constitución, el ordenamiento jurídico, para ver cuáles acciones, si no tenemos acciones a partir de los principios, cómo las aplicamos a casos concretos. Aquí en esta oportunidad, cómo íbamos a proteger el derecho a la vida, la salud de estos jóvenes, pues dentro de las determinaciones, al concluir que la Amazonía era sujeto de derechos y nosotros, sus representantes, le impusimos una orden al gobierno nacional, a los gobernadores de los departamentos, a las organizaciones que están creadas, sí, jurídicamente como personas públicas, para construir un pacto intergeneracional que lo denominamos PIVAC, Pacto Intergeneracional por la Vida de la Amazonía Colombiana, y fijamos unos plazos de corto, mediano y largo alcance para construir este pacto, donde los gestores de la acción y otros participantes de la sociedad puedan intervenir para buscar la protección en forma activa con los organismos y para que el gobierno nacional se comprometa en adelantar políticas públicas junto con otros ordenamientos. Pero al mismo tiempo el derecho fundamental intergeneracional, pensando porque como han señalado ustedes, a partir de los hechos concretos es como podemos edificar las acciones, sí, ellos garantizar la posibilidad, sí, aun cuando eran de distintas ciudades, sí, de que se les pueda conservar la salud frente a los temas contaminantes que le afectan la piel y otros fenómenos. Y aquí para concluir finalmente, eran de distintas ciudades, algunas zonas los demandantes de zonas costeras, otros de zonas alejadas de la Amazonía. Hay estudios serios, es el pulmón del mundo y a pesar de que es la Amazonía la que se destruye, pues naturalmente esa destrucción incide en el habitante de Madrid, en el habitante de Barranquilla, de Bogotá, así no esté en Leticia, la capital del trapecio amazónico. Con muchas gracias, me excusan que me haya extendido aquí 5 minutos adicionales y por la invitación que me han hecho y estamos atentos a responder algunas preguntas. Muchas gracias.
Thank you very much. Justice Michael Wilson of the Supreme Court of Hawaii.
Thanks. Aloha, which is what we usually say when we begin a talk in Hawaii. And of course, Hawaii is on our mind, partly because I know you're thinking about the hurricane, but I must say this at the beginning, that it is often thought of as the ideal environment in the collective human consciousness. So right now, there is a threat that is of existential proportions that Hawaii hasn't really faced in modern history in terms of Honolulu, Hawaii, our major city. So forgive me if I'm overly enthusiastic about this discussion having to do with climate change and judicial remedies. So, as judges, we had our president of our Conference of Chief Justices and the Chief Justice of Vermont point out we are expected to come up with just solutions that apply fairly to all the parties, despite the fact that we might be on something like the Grand Plaza in Paris with cars running in all directions, which is a good analogy. But let's think then about the tools that judges have when they're faced with what might be a chaotic and scary situation. Because when we do think about remedies, we tend to think of it in terms of a formula that's pretty straightforward. If you're a judge sitting in your chambers and there's a request for a temporary restraining order for you to take action and use your equitable powers, you generally think, well, how serious is this? I might need to go home, I'm tired, I'm not sure I want to have a hearing right away. Let's see how serious the threat is. And after all, you'd also consider, is there really anything you can do about it? Is there a remedy? So it is a real cold water in the face wake-up call when you're a judge and you're asked to use your judicial powers in a way that's going to solve a problem that might be considered something of an emergency. And from the point of view of a judge who is facing climate change and considering the remedies that are available, judicial remedies, let's consider for a moment not just the judge, because there is a participant in the judicial process that, if allowed, if able to overcome the obstacles that apply to citizens acting as judges, at some point there will be a judicial remedy that will be imposed by the citizens who sit, at least in the United States, in an extraordinarily powerful capacity. And as we all know, when they sit as judges, they are our equivalent. They will have a chance to make a decision, and they will come from a segment of society that often isn't represented, maybe you could say by us, because they could be young people. They could be young people facing something. So when we go through the scenario of what kind of a threat there is, what kind of remedies should be available, let's consider it not just from our point of view, the judges, but from the point of view of the other judges. It'll get to sit someday, perhaps, the citizens. And what is the threat? It's a really remarkable thing, and I have to say to Professor Zelke now, because of the stirring words that you made, I have a wonderful law clerk whose name is Lucy, and I want to mention to her ahead of time this has nothing to do with her, but if you wouldn't mind taking a break and being my law clerk, I would really appreciate it. That was a very nice offer.
Hawaii would be great.
Okay, yes, we are in Hawaii. Okay, so looking at it from the perspective of a witness such as Judge Zelke, but also a witness who we have in our audience, who is probably the person that's witnessed the ocean more as a woman than anybody on earth, Sylvia Earle, and referring to the witness that spoke about 2 months ago, who was the prime negotiator for COP21 along with Lauren Fabius. His name is Sir David Knight. His point and Dr. Earle's point was that actually this kind of a threat is something that has never been seen before. It's existential, and as Sylvia Earle puts it, if we don't come up with solutions within the next 10 years, it will definitely affect the next 10,000 years. So, getting back to remedies and what a judge is supposed to do when you hear
the prime negotiator, one of the world's leading atmospheric scientists, Sir David Knight, speaking on behalf of his experience, and also here, Dr. Earl. You question, do we have any choice when a case is brought? Do we have any choice to do something when it's such a threat that, as Dr. Knight said, you know, within about 40 or 50 years, 110 million people have to leave Bangladesh. You've probably heard the new word in the last couple of months that has come out from the International Academy of Sciences and a number of scientists who've used the word hothouse Earth. Because now we're getting to the point where it's not uncommon to have a temperature in the range of 50 centigrades or 120 degrees Fahrenheit where people just, especially young people, just start to die. Dr. Zelker talked about how this isn't something for the future. Well, we're trying to avoid a future of 2 degrees, and I'm describing the present right now. But if I were to ask you to do a thought experiment and think about where we're supposed to be by the year 2100, it's not the future we're trying to avoid at 2 degrees. It's a breathtaking future that doesn't really include, perhaps, judges, because the Earth will be so destabilized. In an environmental democracy, which one of my heroes, Justice Tolosa, referred to, who wrote the decision giving rights to the Amazon, we may not have that kind of a stable judicial system, because at 3 degrees, what will happen is, looks as though the Amazon will actually be igniting. The cycle that will kick in will mean the possible depopulation of the Earth going from 7 billion to 400 million within 50 years. So, when you get back to this idea of the lawsuit that's going to be brought in front of a jury that could include young people that see what's going to be happening in the future, if certain practices are not ended, you can see they'll be ready for a big remedy. A really big remedy. So hopefully there'll be some judicial participation from the point of view of not our judges as citizens, who eventually are going to do something about this, I would suspect, but our judges who are now sitting. So if I may take a moment to speak about this idea of equipping ourselves. There are problems that are enormous problems throughout not just the United States, but other countries, that have to do with families and have to do with drugs. And we have courts that have stepped forward to provide specialized treatment on these issues. Family courts were developed within the last 60 years, and drug courts within the last 20 years have proven to be a success. Now, human trafficking, drug courts, family issues can threaten the future of society, but not threaten it in the sense that is so unique in terms of remedies. And I conclude with this concept that I would ask your guidance on in the future in trying to decide how we should deal with this in Hawaii, because in 30 to 40 years, Waikiki will flood. That's billions of dollars. We are already seeing extreme weather events that could destroy our watershed and therefore destroy our water system. So the point is, what makes this issue so unique in the sense of never having happened before with society is its solution horizon. We only have, depending on, and Sylvia, I know Dr. Earl will do a great job at defining our solution horizon, but the solution horizon, how much time do we have in order to avoid the destabilization environmentally that will mean there's no going back? President Obama said that the greatest issue, the most important issue facing humanity is climate change. And of course, he has seen drug problems, he's seen war, he's seen terrorism, he's seen human trafficking. So when it comes to judicial remedies, perhaps it could be time for a court that takes care of these issues, an environmental court. Because those issues, you might argue, eclipse the issues that deal with domestic violence, eclipse the issues that deal with drug addiction, that are a scourge for our communities. And then there's the Global Judicial Institute on the Environment. This is an organization that has as its, I guess, core, imagine Mara Andrade, a judge in the middle of the Amazon, a federal judge who has to decide whether she's going to protect the Amazon from illegal deforestation that's designed to create great economic benefit from the point of view of a soybean plantation. And the environmental laws that apply are broken, so she has to decide whether she's going to shut down an economic development program for people that are on the edge of survival. And she gets worried, because who's her constituency? Eccentric NGOs? Probably not the indigenous people who want a job. And certainly there is an enormous group out there that Professor Zelke has alluded to that has great power and influence that's already been able to put a project like this together. So the Global Judicial Institute is sort of for her, because we need to help each other. This path that is like being, as Chief Justice Reiber said, in the midst of a chaotic train wreck, a chaotic car race. This is an enormous threat, challenge, if you will. You could call it an unprecedented struggle that the men and women that are judges are going to have to face as we get to 3 degrees, as things deteriorate. So, I want to thank the organizers of this conference, especially the legendary Claudia DeWitt. Thank you, Claudia, for putting this together, and all the members of the World Judiciary that have been here. But I will thank you for whatever kind of guidance you can give on this issue of what should the men and women that are facing climate change in the future do about applying creative remedies to what could be a potentially existential threat. But I hope we can do it in an organized way, and we can do it in a way that protects us and protects humanity, and also protects that group of people who, there are 2 billion of them, and they are the ones that are going to suffer the most and are already, because those are the 2 billion people that are alive today that are children. I will say aloha to everybody, and please come visit our island. It'll be beautiful during our lifetimes, I know that, and it would be wonderful to have all of you there. Thank you. Aloha.
Okay, it's question time, and I understand that we are starting off here, Michael and I, and I wanted to ask the speakers about what special techniques can your courts fashion to manage climate change cases. In terms of appointing special experts, special masters. How can we manage these incredibly complicated cases? And then I have I'll give you 2 questions at once. The second one follows the Justice Wilson's comments on remedies. How do we enforce our remedies? I mean, I'm good friends with Tony Aposa in the Philippines. He did his brilliant case in 1992, 93, and it was great. The Aposa doctrine was established. But what happened to the forest? Okay? So if we don't figure out how to enforce our remedies, we're not going to win either.
In terms of how, in particular, a country the size of Barbados could manage climate change cases. Well, I'm not the Chief Justice. I'm only speaking from my own personal background of knowledge, and this is my personal opinion. I don't think that it's feasible for Barbados to have a designated environmental law court. We're a very small jurisdiction. What I do think is feasible is that perhaps some of our judges could be trained in environmental law and perhaps become specialists in it. But the whole idea of having a designated environmental law court to deal with these serious issues. And it's an extremely serious issue, especially against the background with Barbados being a small island developing state. It's not practical to have a designated environmental law court, but we can have judges who are specially trained in certainly the effects of global warming, climate change, all of those important issues.
Thank you.
Bien, el tema del medio ambiente en nuestro país frente a la cuestión, no tenemos una jurisdicción autónoma, tenemos varias jurisdicciones. La Constitución de 1991 introdujo distintas modalidades de jueces, un juez contencioso, administrativo que conoce de controversias contra el Estado y judicializa actos administrativos que profieran las autoridades, por ejemplo, una licencia ambiental. Entonces, pero ellos conocen dentro del marco de todos los conflictos que conocen frente al Estado. Responsabilidad, temas laborales. Y yo me encuentro en la jurisdicción ordinaria, que básicamente es la Corte Suprema, el tribunal más antiguo, y el tema de los tribunales, el tema ambiental no tiene un juez natural propio. La controversia del medio ambiente llega por vía del juez civil, los jueces civiles, o eventualmente algunos jueces penales. Esta jurisdicción ordinaria, el tribunal más alto es la Corte Suprema y está dividida en 3 salas. La sala civil, la sala laboral y la sala penal. Cuando se criminaliza una conducta ambiental, llega a la sala penal y allí pues se le aplican las penas que genera o sanciones el derecho penal, y los temas que tienen que ver con el medio ambiente llegan si son relacionados con la zona rural o agrario, llegan a la civil, o si tienen que ver con el derecho empresarial, el derecho mercantil, también a la sala civil. Todo el tema distinto a la penal llega a la sala civil, pero ni en la Corte, ni en los tribunales superiores, ni en los jueces tenemos jueces independientes para trabajar el tema ambiental. No sé si le haya respondido la pregunta o le complemente algún otro detalle sobre su cuestionamiento.
Well, I'm still interested. I don't work the damn button. What other techniques might you have, Justice Tolosa, for appointing your own expert witnesses, perhaps, or a special master, even if you don't have an environmental court? Are there techniques that would help you with complicated climate cases? Okay. So what, so are there other techniques that your court might have to manage complicated climate cases, short of the environmental court? For example, appointing your own experts to help you understand a case and fashion a remedy, maybe even using a special master to retain jurisdiction to make sure that your judgments were enforced.
Respecto de su pregunta, los únicos jueces son los del Estado. Ahí están los tribunales de arbitramiento, que sabemos pues, son particulares que ejercen temporalmente jurisdicción, pero frente a las acciones que tenemos, una de las acciones que mencioné fue una acción constitucional de ágil y rápida solución que que en 10 días hábiles se tiene que resolver o en 20 días la segunda instancia. Ahí, además de ese remedio judicial, existe una acción de un término más amplio, que es la acción popular para proteger derechos colectivos y procedimientos ordinarios. Ahora bien, frente al tema de los peritos o expertos que puedan dictaminar sobre el problema ambiental desde el punto de vista técnico, corresponde a elementos probatorios que se pueden acopiar por la parte interesada y aportarlos, o por tratarse de orden público ecológico, porque la Constitución es marcadamente ecologista, ¿sí? Sin que haya plasmado categorías como la madre tierra del Ecuador o por donde camina la Constitución de Bolivia. La nuestra tiene una serie de principios ecológicos. Entonces, al practicar la prueba oficiosamente, motu proprio, el juez mira el caso y puede decretar pruebas técnicas sobre el particular. En este caso, por ejemplo, de la Amazonía, tomamos mano de informes científicos y técnicos que tenía el Instituto de Meteorología en Colombia sobre estudios de la cantidad de deforestación por la incursión de paramilitares y sobre todo que el proceso de paz reciente que se adelantó con ocasión del Acuerdo de La Habana generó un vacío, y entonces porque la guerrilla colombiana estaba habitando o ejercía el control territorial sobre la Amazonía. Ese vacío fue llenado por mineros ilegales, compañías mineras ilegales, fue llenado por bandas criminales, por paramilitares, por cultivadores de coca y muchos, la tala y el transporte de madera para ampliar la ganadería extensiva. Entonces, allí esos datos científicos que han recopilado algunos organismos, ¿sí? Y algunos dictámenes que dieron expertos, ¿sí? Incluyendo aquí, no me acuerdo el nombre de un profesor norteamericano, envió el dictamen allá. A partir de esos elementos técnicos decretamos la protección, porque por supuesto que hay que utilizar, en estos temas ambientales es necesario acudir a las pruebas técnicas, porque como lo planteaban algunos jueces esta mañana, pues es el debido proceso y hay que observar las partes que intervienen, la multinacional, por ejemplo en el caso de la Drummond, o en este caso pues los que tengan interés hay que notificar a las entidades, en fin. Entonces hay que tener pruebas técnicas porque hay que observar el debido proceso. Entonces el dictamen pericial o una decisión no la adopta un perito, sino que la concentra el juez del civil law o el juez de nuestro derecho. Ahora, dictada la decisión, la última parte que me traía la pregunta es cómo se cumple. Entonces, la decisión tiene que ser concreta y el juez tiene que ser capaz para plasmar un código, de alguna manera, una reglamentación que pueda alcanzarse en el tiempo y que se pueda ejecutar para que la decisión sea eficaz. Porque el problema que tenemos en América Latina y en Colombia de pronto es por la cantidad de legislación que tenemos, o digamos que son muy ricos los ordenamientos últimamente en América Latina sobre la disposición para proteger el medio ambiente y, por ejemplo, Colombia ya se adhirió íntegramente al Acuerdo de París 2015 y se comprometió a cero deforestación. Entonces, en ese punto, de alguna manera, son ágiles los congresos y los ejecutivos, pero la práctica de ellos va atrás frente a la norma. Entonces, el único que puede tornar eficaz es el juez, digamos, llevar a los hechos concretos a la práctica para la protección del medio ambiente en toda América Latina y en Colombia, porque eso ocurre. Entonces, la manera como están los principios, pero por fortuna tenemos esas acciones donde cualquier persona puede. Ahora, en la sentencia hay que fijar unos parámetros concretos, ¿sí? Hay algunas decisiones que tienen más de 20, 30 decisiones. Por ejemplo, la decisión del río Atrato, la parte resolutiva prácticamente se convierte como una especie de código concreto sobre esa decisión, porque en este punto han estado expidiéndose decisiones por parte de la Corte Constitucional, de la Corte Suprema, de los casos que llegan ahora. Existe para el cumplimiento, por ejemplo, en el caso de la tutela, que son acciones constitucionales cortas a la mano de la ciudadanía, ¿sí? El incidente o trámite de desacato. Si se incumple la decisión, por ejemplo, porque no se entregó una medicina, porque muchas veces la necesidad de nuestro Estado implica que el ciudadano a través de la tutela reclame la medicina o reclame la cesación de un acto violento. Y en este caso de los códigos ambientales, pues nosotros hemos fijado algunos plazos que se tienen que ir cumpliendo en el tiempo y el juez de primera instancia, así no haya sido el que haya protegido y haya sido su decisión la que se haya revocado, es el que tiene la obligación de hacer cumplir la decisión. Y, por ejemplo, en el caso de la tutela, por eso, no es que no haya otro tipo de procedimientos, los hay, pero son más lentos en el tiempo, ¿sí? De menor eficacia frente a la decisión. Puede pedir entonces en ese trámite de desacato, que también es rápido, que se aplique sanciones o inclusive el arresto a las personas que deben hacer cumplir esa decisión.
Well, you have asked the question about the way to implement, I suppose, and asked that question in reference to environmental courts, too. So I think it's interesting that in some ways maybe the issue of environmental courts is shown here, because to be able to implement what you rightfully describe as oftentimes very complex issues, particularly dealing with climate change, there has to be a certain will to do that, backed with knowledge. And actually, the Chief Justice of Ohio spoke about the importance of having some enforcement mechanism, having an attorney general that's motivated, or having the kind of, and one way for this to happen along with an environmental court. I'm not sure whether this is something that can work very well unless you have a judge that's trained in these issues, that consistently does it, who's recognized by the community as being that person with the capacity of coming up with a fair decision that and this is one of the things that defines an environmental court, a person that's got training. But in the country of China, there is a cadre of prosecutors. In Brazil, there's a cadre of prosecutors who prosecute government officials and private entities that do not comply with either a statute or orders of a court. But with that kind of a will that comes from something other than just the individual judge, I think there's ample opportunity to do it. And without an environmental court in Pakistan, the judge who had the case in Pakistan of climate change ordered the country to produce a climate change action plan, and the country did. And then this judge, Judge Mansoor Ali Khan, maintained jurisdiction. In India, the Green Tribunal has issued an order and then also appointed a commission to follow up on it. So I think that's one of the great environmental courts in the world, the Green Tribunal, but the idea of having to monitor a court order when you have an opposition like in India, the opposition to the issue of getting diesel cars off the road or cleaning up the Ganges was an extraordinary powerful industry. So a commission being appointed, a certain enforcement authority being available would achieve a result that's much different than Tony Oposa's case, as you rightfully point out, because there wasn't a commission to follow up on it. There wasn't the kind of will to follow up on it from the point of view of the court. So I'm inclined to think that the will continue to grow because of the seriousness of the problem and that need to have informed informed experts who can follow through and implement a decision of a court is likely to increase.
The greenhouse gas emissions from Barbados are very small. The greenhouse gas emissions from Colombia are very small, and so are the greenhouse gas emissions from Hawaii. So if your courts issue orders that require your own countries to reduce their greenhouse gas emissions, that will have only limited impact. Can you think of ways that your courts can take actions that will have broader impacts, that will have impacts beyond your countries?
Well, certainly. Certainly in respect to Barbados, we can pay due regard to our international obligations, continue to pay due in the face of what I stated earlier, the fact that as a small island developing state, we are not the initiators of global warming. We can continue to acknowledge and comply with our international obligations, at the same time pursuing diplomatic efforts to bring attention to our plight and to persuade the more developed countries that we are in need of assistance. That's quite a difficult question you're asking in terms of the greenhouse, because it's practically none. We have I think it's 0.01 or something like that. So the best that we can do, because the truth is that as a small country, we don't have much leverage in terms of a voice, but we can continue to try to be heard and continue to pursue diplomatic efforts.
Bien, respecto de Colombia, frente al punto que se plantea, el primer aspecto de la posibilidad de que el juez pueda emitir una orden que tenga repercusión externa en otros estados por el carácter mundial que tiene la contaminación no global o fenómenos del impacto ambiental. Es un tema que está en construcción y se requiere dar el paso por los jueces de los distintos estados, porque por eso me parece relevante que el primer punto, desde el punto de la contribución que pueden hacer los poderes judiciales y los jueces en el mundo, tiene que ver con el cambio de paradigma, de dar el paso de un modelo antropocéntrico, ¿sí?, regional, insular, a un modelo ecocéntrico, antrópico. Y si en este aspecto todos somos perjudicados como ciudadanos del mundo, ¿sí?, que es el punto que planteamos y creo que la acción colombiana de la tutela lo tiene, es decir, cualquier persona, legitimación universal porque no se requieren mayores requisitos, sino que haya sufrido el perjuicio, algo así como en las acciones reparativas, donde el legitimado es el que ha sufrido el perjuicio. Entonces, si yo sufro el perjuicio, yo creo que teniendo en cuenta ese elemento básico que está en el derecho romano, el principio neminen ladere, el que causa un perjuicio debe repararlo. Y si yo por rebote o indirectamente o directamente sufro el perjuicio, puedo plantear la acción ante el juez para efectos de que tenga, al menos desde el punto de vista de la legitimación por activa del actor, el que puede ir a plantear la acción. El punto tiene que ver con la legitimación pasiva, y es decir, quiénes son los obligados, porque se trata, nosotros nos encontramos en el marco jurídico como jueces. Uno, pues somos jueces regionales. Dos, la jurisdicción mundial, las jurisdicciones, los tribunales internacionales, el problema principal que tienen es la poca posibilidad de hacer coactivas, hacer cumplir las decisiones, porque pues si el Estado no se ha adherido al tratado, si no ha participado o si ha hecho reservas, pues el punto que tenemos frente a la construcción de una justicia universal. Yo creo que, por ejemplo, en el derecho español se intentó y fue fructífera en el caso de la violencia en Chile, el juzgamiento que se adelantó. El punto es cómo un juez de Argentina o un juez de Chile, un juez colombiano, puede impactar decisiones de otros estados frente a temas que atañen a toda la humanidad. Ese es el punto, es decir, la legitimidad, porque hay que proferir órdenes contra alguien, y ese alguien muchas veces está fuera del territorio nacional. Entonces, ¿cómo hacer eficaz esa decisión? O sea, la legitimación, ¿quién es el obligado? Si yo soy el perjudicado porque estoy en Uganda, o porque estoy en Cincinnati, pero la fuente del riesgo está en Colombia, creo que en los sistemas podemos encontrar una manera, y es la acción. Si el que sufre un perjuicio puede reclamarlo. Ahora, ¿contra quién? Contra el dañador, el causante del perjuicio, los elementos centrales de las acciones reparativas o del daño. Entonces, el problema es cómo cobijar desde una jurisdicción nacional con efectos obligatorios, ¿sí?, a quien está en otro estado donde está la representación y que puede obligar, porque el representante legal de una entidad, ¿sí?, cuando viene la decisión, pues liquida su sociedad y se va para otro país, ¿verdad? Entonces el tema es cómo hacer obligatorio es el tema en construcción. Y pues hay que dar el paso. Ahora, comparto la posición que plantea la ministra la jueza magistrada de Barbados, en cuanto a que realmente los países, nuestros países propiamente no son causantes de los problemas de polución o de contaminación, pero claro, contribuimos. Y no, pero existen también, o sea, se están presentando los problemas, por ejemplo, en Medellín y en Bogotá, digamos, el fallecimiento de personas por problemas pulmonares, el cáncer de piel, por ejemplo, la modificación, porque no se trata de un problema regional, digamos, entonces, sino se trata de un problema mundial, ¿sí? Lo importante me parece aquí, y por eso tomé la alternativa de acompañarlo en este foro, es ver cómo creamos una conciencia colectiva, ¿sí? Y sobre todo desde lo judicial, en nuestros países donde son muy frágiles las decisiones del Ejecutivo o las decisiones del legislador. Entonces nos corresponde a los jueces, bajo el esquema de la autonomía e independencia judicial, ¿sí? A otear nuestro ordenamiento y los principios para ver cómo, cuando se presenta un problema de esta naturaleza, lo podemos hacer eficaz. Muchas gracias.
Well, it is a challenge, and as both Justice Weeks and Justice Tolosa have said, it's a bit of a challenge to be from a small jurisdiction, but actually, you think about how small the world community is, and as Professor Zelke pointed out, let's just theoretically assume that there's a handful of actors that are responsible for us not being able to keep the Earth from getting to 2 degrees. And that creates global warming that floods Barbados, and it starts destroying the Amazon, and it's flooding Waikiki, increasing extreme weather events, and our jury decides, maybe in all 3 places, there's a decision in all 3 places, that those handful of organizations that may be capitalized at well over $1 trillion, it's actually time for them to accept responsibility. So every time the president arrives in Barbados from that company, or arrives in Colombia, maybe Tuvalu that's going underwater, or the Maldives, there'll be a motivated group of, I guess we could call it climate change people, identify themselves as sort of climate change people, that might be interested in making sure they stay there until they make amends. Now, we're assuming about civil action. It is, of course, not beyond the rule of law that it would be a crime if you were purposely releasing plutonium into the atmosphere so that there's a certain small community in the Midwest of the United States where it could be identified that there were citizens that were dying because of the plutonium. I suppose these are things that could be done through the private sector. I mean, if you focus on the fact that the United States, China, India have the largest carbon footprints, who's most responsible for this? Maybe it's not the countries. But if a whole bunch of little countries, I mean, Hawaii's not a country, so we're a little bit more limited in an opportunity to participate in this activity. However, you know, stranger things have happened in terms of little ideas becoming big ones that mean, as the head of 360, Bill McKibben, says, you know, there are a lot of little countries, a lot of little people that are being affected by bigger, more wealthy. If you look at the wealth creation that has to take place, if you're looking at damages for British Petroleum after the contamination of our most prolific ecosystem in the Gulf of Mexico, and you have to start looking at the wealth that is pulsing and becoming greater, it sends a message that perhaps the organizations that are able to continue to explain why we shouldn't get carbon out of the air are really benefiting from it. And if a jury sees that and issues an award in Hawaii, are there, under the rule of law, ways to be able to enforce that? I think that that's pretty straightforward. So I'll conclude with Gangnam Style. Have you all heard of Gangnam Style? It is an amazing phenomenon. that points out, it reminds me of our president, Barack Obama too, because things happen that you would never expect. You know, Barack Obama is a community activist. He comes from a place where there was a challenge as to whether he was even born in the United States because he's from, you know, Hawaii. And if you look at his background, he really was not supported by the traditional powers that provide support for contributions. But he became president in large part through the internet and because of this viral thing that happened. Gangnam Style was the most popular song in the history. Had 3 billion hits after just 30 months. And it gets me back to this idea of counterintuitive things. You know, Barack Obama became president. Gangnam Style was the most popular song, and it was in Korean from a person that's not a good singer, who's kind of a crackpot. So, yes, you know, Hawaii, Colombia, and Barbados are sort of small, but I think we believe we could make a difference in certain ways, yeah.
Oh, okay. I just want to add that I agree with all that has been said in respect of the question that was asked, but perhaps what we need to do as smaller jurisdictions is, aside from what we just said and the diplomatic efforts, aggressively pursue education programs, public education programs, so that we have the public with us whenever we make a decision. I know there's supposed to be that separation and whatnot, but it would be useful if once the court made a decision, particularly in a small jurisdiction, everybody understood why the decision was being made and the background against which the decision was being made. And that would include public education about things like global warming and all of that. I mean, I know that people think that we've been talking about it for years, but unless you are in people's face, as it were, on a daily basis, speaking to them about a particular issue, they won't necessarily acknowledge the importance of it in their everyday daily life.
We have time for a question or two. If anyone has a question, please press the button on the left to acknowledge. Give it an attempt. Does anyone?
Yes, I do.
Yes.
Thank you very much, Professor Gerard, and again, congratulations to all of you. Wonderful panel. I just wanted to point out something very quickly to hear what your experience has been on this. In the hemisphere, the cases that relate to climate change are not necessarily obvious. What we've noticed is that while there are some cases like the recent decision in Colombia that we've heard about that are explicitly climate change, there are others that focus on other areas that scientists have pointed out as the greatest areas of impact of climate change in the region, like ecosystems, extreme events, or water security. So I just wanted to see if you had any experience on what the trends are being on the issue of climate change in courts in that sense.
Well, I'll say, since we track a lot of this, you're quite right that not all cases that are relevant to climate change are explicitly termed that, and the cases on deforestation are especially significant. We've heard about the Colombia case. There are several cases in Brazil that have concerned the impact on forests. There are a number of decisions concerning transport mechanisms where road transport, which are major sources of greenhouse gases, they're not necessarily framed as climate change cases. In the United States, we have many lawsuits against coal-fired power plants They are not all on climate change theories, but many of them are motivated by climate change. So we have a large volume of litigation that is relevant to climate change, even though it is not explicitly framed that way. Any other questions? Okay.
One more.
Just one question or one thought. I mean, climate litigations, they are or can be very important, but on the other hand, what we know is that we have very little time to fix this problem. 15 years were mentioned, and we also know that although so many positive things are happening around the world, worldwide, the emissions, they are still increasing. And they are not increasing a little bit, they are still increasing. So we are not on the right way. And then knowing also the time that court uses to work with cases, how kind of, what can one expect through court cases? So this is only a reflection, and I mean the other thing is that you never know what will be the outcome of a court case, which is also a big risk. But my question now is kind of, I think as persons, we have a kind of a responsibility also to try to make our use or to, I don't remember the English word, but to try to influence society in other ways. And my question was, how is that in the different countries that you come from? Can a judge say that I think climate change is a very important question, that the government should work hard on it and things like that? Could that be said publicly by you as judges in your countries?
Right. Probably privately, you could make a suggestion or give a hint, but I think that question would fall in the realm of policy, which would be something that the executive would have to deal with, the government would have to deal with, but quietly, perhaps a judge could say something.
Ask maybe, Ronhild, for you to give some thought to what is a judge supposed to do when you're asked whether you think it's a good idea to discriminate against somebody based on race? What are we supposed to say when we're a judge and we're asked whether somebody should be discriminated against based on gender? I mean, I think that's universal. I can say with confidence in the United States, if somebody asked me whether I thought it was true that there are certain minority groups that are more inclined to commit crimes, or it's true, whether it's true that it's a good idea for a certain category of individual to be incarcerated more often than another. We have, I think of my oath, we're sworn to uphold the laws of the state of Hawaii and the Constitution of the state of Hawaii and the Constitution of the United States. Am I upholding the Constitution when somebody asks me if it's okay to discriminate? Okay, if there is something called a right to a clean and healthy environment, which we concede we have in our state, we can be apologetic. We can try to back off. Because if you talk about protecting the environment, maybe it means that you have to engage in a balancing where somebody else doesn't get exactly what they want. But when we're facing an existential threat and we've only got such a short time to be able to protect humanity, and we're the ones that get to see it, we see over the horizon, I tend to feel that to give a public presentation and say these are the issues that have to do with climate change, these are the laws, and we have an obligation to take certain steps to make sure that the Earth is protected from what is clearly a threat. it's not something that we need to be either apologetic for or feel is inconsistent with our role. Yes, the choice of words is important to assign blame to a certain group, to say that it's somebody's fault necessarily. Maybe that is a departure from the role of a judge, but to address the issue and talk about how important it is for us to recognize that the rule of law does apply. I mean, if you're asked the question whether it's consistent with the Constitution to have a 3-degree world, with the kind of devastation that goes along with that, maybe that's a little bit uncomfortable, but still, it raises an important question if you're asked that by a law student who is interested in whether or not there's some duty as a lawyer to maybe say something about the fact that this is an impending catastrophe that will affect human rights in a way that, I mean, in a way that's, you know, there's a very little historical parallel, right? So I don't know, what do you think? I know Norway I think of as having such wonderful values, but do you think it'd be uncomfortable to talk about the importance of applying the rule of law to climate change in Norway?
I don't think that would be problematic, but I think also it's a question of form, that you have to say this in a kind of a form which is kind of balanced or not very extreme in a way. But I think it would not be problematic for a judge, for me, in Norway to say that I think climate change is a big problem. But another thing is that I restrict myself, and other judges also restrict themselves very much, so they don't say it. And I think that's maybe because we have a notion that we should be very neutral, we should not be connected with any political case. But principally, I don't think it is a problem if you, because the climate change is something that is, it's nothing to wonder about. It's a fact. So in a way, I don't understand why it should be a problem.
Right. I agree with Rangel. I'm sorry. I'm sorry. Was he speaking?
And then he'll follow you.
Okay. I agree with Rangel. I do think that, and also Michael to a large extent, but I dare say my initial response came from the type of jurisdiction that I am from, where certain matters are usually, especially if they've been filed in the court system, they're considered sub judice. There isn't any public discussion on it, or at least there isn't supposed to be any public discussion on it. And there's also the danger sometimes of, and I agree that climate change is a fact, but at the same time, we don't want to appear biased either. You don't want a scenario to arise where someone might, an organization might have a matter before you, or an individual might have a matter before you, and they might say, well, because of your public pronouncements on this matter, I consider that you are biased and I need you to recuse yourself from this case. So there are elements of both what Michael said and what Rangel said that I agree with, but at the same time, it's a very, very, very thin line that we have to tread as judges, because when it comes down to it, we don't want to be accused of bias in a particular matter, even though we may all have our private opinions.
Quiero agregar en este punto que en muchos estados tenemos la posibilidad de plantear expresamente los problemas del cambio climático. Y eso justamente de forma explícita y no implícita, expresa claramente afrontando el problema. Cuando no tenemos una legislación propia sobre el particular, podemos acudir a los principios generales. Hay algunos estados que, por ejemplo, los participantes en el Acuerdo de París 2015, cuyas nacionalidades ya se adhirieron, y allí hay una serie de principios o al menos un credo sobre ese particular y se puede concretizar. De modo que sí es válido afrontar el problema expresamente como lo hicimos en la decisión de la Amazonía. Y esto que de alguna manera quería, porque para la época cuando se planteó el problema, los demandantes lo hicieron justamente con fundamento en el acuerdo y sobre hechos concretos. El juez tiene que ser neutral, imparcial, es autónomo, independiente. No, digamos que el tema de ser parcial aquí, como en los temas del medio ambiente, como en cualquiera otro, pero el juez tiene que ponderar, ¿sí? Frente, por ejemplo, a este punto que hablaba el profesor Lorenzetti en la conferencia que envió sobre el tema de la progresividad del derecho, la progresividad, y esto tiene que ver, es un derecho no es individual, pero también colectivo, recíprocamente. Por eso en Colombia hemos dicho que no únicamente a través de las acciones que están en los códigos decimonónicos, códigos civiles, las acciones populares, no sé si quienes hemos sido educados en el ámbito del civil law allá, entonces se dice, no, eso es defensable por vía de las acciones colectivas o de grupo, pero frente a acciones que se puedan emanar de la Constitución, se puede perfectamente y se puede acudir por principios, porque pues el ordenamiento tiene que, no puede, muchas veces no es de principios, son reglas que están expresas para que sean obligatorias, pero yo puedo acudir a los principios. Y justamente nosotros planteamos ese tema sobre el cambio climático. Yo creo que el juez sí puede expresamente. Y allí se planteó, el asunto es que a pesar, como dice la doctora que me presidió en el uso de la palabra y se ha venido planteando, es que lo sentimos, el cambio climático, sí, pero podemos acudir a la prueba que vamos a practicar dentro del juicio cuando se proponga la causa, porque pues yo no selecciono mi causa en el derecho nacional, en el derecho colombiano, o al menos en América Latina no seleccionamos la causa, sino que nos llega de los múltiples conflictos por reparto al que le corresponda resolver el caso. Pero cuando se nos plantea el asunto, lo importante es de que, a pesar de que es un problema científico que está sujeto al principio de causalidad, yo creo que podemos utilizar la prueba pericial, los informes técnicos practicados dentro del proceso para efectos de decir efectivamente este organismo nacional o internacional muestra que efectivamente en este punto de dióxido de carbono, en este punto la deforestación de tantas hectáreas han desaparecido, ha aumentado la tala de bosques, este río tiene tantos contaminantes, aquí la contaminación auditiva, tantas cosas. Creo que a través de la prueba pericial nos podemos apoyar. Muchas gracias.
Thank you. I think we're out of time. I would love to continue this discussion, but we have a very important keynote talk to listen to, so I want to thank our panel for a terrific discussion. Thank you.
Please take your seats. We're starting in 1 minute. Oh.
All right, folks, we're getting ready for the keynote. If you will find your seats. My name is John Cannon, and my sole function today is to introduce Dr. Earl, who is billed in your program materials as a marine biologist, explorer, and author. But that's, I would say, an understatement. Dr. Earl is the world's best-known oceanographer and the world's premier spokesperson on behalf of ocean conservation and issues of climate change relating to oceans, which I think she will touch on today. She is a National Geographic Explorer in Residence, has been since 1988. She was the first female chief scientist at the US NASA agency. She has held numerous research positions and curatorships in universities all over the country. She is an intrepid explorer who's been to the bottom of the ocean, how many thousands of feet I cannot say, in the dark, all by herself, in situations that are so scary I can't even think about them. She has been an innovator in the development of submersible technologies, combining her scientific knowledge with engineering expertise, and I think above all, and for of particular importance today, is her work as an advocate for the oceans and for the planet more generally. She was recognized by Time magazine as the first hero of the planet, and as if that weren't enough, UNEP, a few years ago in 2014, gave her the award of Champion of the Earth. It shows she is both a hero of the planet and a champion of the Earth. And I don't know, I'm sure there are other formulations that will be accorded to her in the future. She is the leader of Mission Blue, which is an alliance to address issues, grave issues with the oceans, and vigorous and tireless in her pursuit of that objective. There's a great passage, I mean, you could go on the line and find so many accolades for her, but one I like particularly was from Dive magazine, which would be perfectly appropriate for her background and interests. But this is what it says about her advocacy interests and activities. There is no stopping her. She never gives up. Her job is to save her beloved ocean, and if that means personally persuading every last one of us, whether school child or president, that would be a big challenge at the moment, she is going to do it with charm and charisma, and I might add, scientific knowledge and experience. There's a great line from the poet William Butler Yeats that I like, where he extols the combination of passion and precision, and Dr. Earl has that. So, Dr. Earl.
Thank you for that very generous introduction. scary as driving in traffic in Washington, D.C. I mean, that's really scary. I suggested to Michael Wilson just before coming up here that the biggest problem facing the world today is not climate change. That's a really big problem, but the biggest problem is ignorance. People who do not know that the climate is changing or why it matters if it does. Ignorance, not understanding. There's a quote attributed to Abraham Lincoln that if the people are with you, anything's possible. If they're not with you, nothing's possible. So if the world really understood what the people here, what you understand about the danger all of us are in right now because of what human beings have done to the only place in the universe that can be our home, where our history is, where our past, our present, and our future is, and where all of those things are, we would not need laws. They would do the right thing, the thing that's in our best interest, and the best interest now and forevermore. But people do not know. They really don't have it in their heart and soul, their minds, of what the magnitude of the issues are. And yet it's strange because never before have we been better informed than we currently are. We've got the evidence that did not exist and literally could not exist before right about now. We are the most empowered generation ever to live on the planet because of the knowledge that has been gained over all preceding time and passed along one generation to the next. And we're the beneficiaries of all that has been learned before. Now, full disclosure, with all those things that were said, I'm not in any way familiar with all of the things that you're familiar with. I'm not a judge, I'm not a lawyer. I'm getting pretty well versed in the laws of nature as a scientist, and everyone should do everything they can with the knowledge that now exists about those immutable laws of nature. Gravity exists. I mean, the laws of physics, the laws of chemistry, the laws of life on Earth. They're things that just exist, they are. We have to understand and live within that framework. We can butt our heads against the laws of nature sometimes and wish things were otherwise, but they are what they are. A 1 degree change in temperature will change everything. Melts ice. At a certain level, it's ice. Just at a different, small change in temperature, it becomes liquid. We can't change that factor. Well, I am a founding member of a small group, international group of individuals known as the Ocean Elders, formed in the same way that the elders who have come together to look at human rights, to look at what we might think of as rights for the ocean, to be a voice for the ocean. And one of the Ocean Elders truly is an elder, and that's Nainoa Thompson from Hawaii, who is Native Hawaiian, highly respected for trying to restore the native traditions and to the people of Hawaii, all people of Hawaii, to understand and respect where they've come from and where they might be going. And the one who dreamed up the idea of having a global voyage using a traditional sailing canoe has sailed around the world using traditional navigation techniques. Amazing. But it just sort of brought things together globally. Respect and dignity for people around the world. Well, I am a mother, and I'm a grandmother, 3 children, 4 grandsons. So I become a judge of sorts. dictating the law of the household. I'm very aware, as once upon a time being a child myself, that humans are born not knowing anything except hunger, pain, maybe fear, whatever. They're born into a world that's extremely hostile to newborns, whether you're a fish or a whale or a tree or a human. It's a dangerous place to come into this world as a young thing. But over time, all animals acquire some knowledge, and humans better than most, because as Ed Wilson, the distinguished ant-man from Harvard University, who is known, among other things, for a book called The Social Conquest of Earth, How Humans and Ants, with our societal formation, have really taken over the world in ways that other creatures have not. It's a social organization, but in the human world, it's not just the genetic passage of ways and means of doing things by whatever selection processes go on, the laws of nature. But we learn and we pass things along. We use this thing with which we are gifted, our brain. And we're not unique in having good brains. I mean, think about elephants, what they know. Think about what albatrosses, big birds, know. Their navigation techniques that are in some measure learned. They learn the way. Cod learn the migration routes over which they travel. But we're better at this business of learning and passing knowledge along than any other creature that exists, as far as we know, in the universe. So what are we doing with our knowledge? We are new arrivals. We're newborns on a planet that goes back a long time. However you measure, we think 4.5 billion years. So, think about how the world was 1 million years ago. There were humans, or humanoids at least, 10,000 years ago. The beginnings of civilization were clearly in evidence. 5,000 years ago, 500 years ago. But 50 years ago, the middle of the 20th century, that truly marked a turning point. Up until then, and even now, in the minds of many, we thought Earth, generally speaking, was too big to fail. We thought we could get away with cutting trees everywhere. They just grow back, right? Sustainable use of forests. We still think that about fish. Clear cut the fish, they'll grow back, right? They're not. The trees aren't coming back the way they were before we started cutting those 1,000-year-old giants out of California. So many things that we now know that we could not know before we had the evidence. All of us are now witnesses to a time of greater knowledge, but greater loss than during any time in our history. So, we have exceptional powers, superpowers, that our predecessors would really envy. If they could have known during the time of Galileo what Galileo was just beginning to suspect centuries ago, that Earth is not the center of the universe, and we are not the center of Earth, that we are part of nature. And Galileo was really ostracized for his outlandish way of thinking. Today, we would say it's outlandish to think otherwise. We know, we got the evidence. Earth goes around the sun, not vice versa. But it took, it wasn't that long ago that these amazing things that we take for granted today, that we know the moon is not green cheese. Well, most people know that. So here we are. at this amazing point in time. Now, as never before, we know we've got a problem, and that is real progress. If we did not know, we would go merrily on our way, as we have been during all previous human civilization, consuming nature as if it doesn't matter what we take out of the ocean or out of the land. How many furry things that we kill to get their nice furry hides to decorate ourselves or just to keep us warm. We did not know the cause and effect, the consequences of the impact we were having. Well, all creatures, all living things, even right down to the tiniest microbe, all living things use their environment around them to foster their prosperity. They all need space, need food, need some means of reproduction, and to do that, you have to consume your neighbors or something. But nobody does this business of consuming the natural world better than humans. Well, maybe I shouldn't say the word better, but more comprehensively than humans. And much of the consumption has paralleled our advances in technology. We're capable of cutting trees, capable of putting into the atmosphere things that we couldn't do it 1,000 years ago, we just couldn't. But now we can. It's partly because of our numbers. Go back to 5,000 years ago, how many people were there on the planet? Well, it took until 1800 to get to even 1 billion people. And by the time I came, there were 2 billion, and I've been a witness to pretty close to a quadrupling of our numbers in my lifetime. Yeah, I've been around for a while, but not that long, geologically speaking. I mean, so if I could, I would show a few images to finish my comments to illustrate them, but I'm going to have to ask you to please use your imagination with some images I'd like to encourage you to bring to mind. And the first one is something that used to be so easy to see. If you would go out at night, almost anywhere on the planet, you could look up and you could see the Milky Way, the edge of our little piece of the swirling universe that is our little chunk of our galaxy. It's really hard in cities today to look up and see the Milky Way. But you can get to a top of a mountain, or you can go out into the ocean. You can go to Hawaii, one of the best places to view the Milky Way, on one of those mountaintops or out at sea. Barbados has got to be a pretty good place, too. All right, so do that, and then think about how beautiful all those little sparkly things are. And to realize that in all of the world, all the smart creatures that are there, the elephants, the big cats, the dogs, the horses, the dolphins, the whales, they may admire them too, but they don't know what they are. We're the only ones who can look up and say, we know what the stars are. Go back 1,000 years ago. Our predecessors were really smart humans, but they did not know what stars are. Now we know. Ah, what a gift. And to realize, the second image to draw up out of your minds, you probably have, every one of you seen it. It's that image known as Earthrise, taken about half a century ago, 1968, by General William Anders, who was astronaut Anders on Apollo 8. Just by chance caught a glimpse as their little Apollo capsule was up there in space of the Earth as viewed from the curvature of the moon. Oh, what a view. It's now considered to be the quintessential view of the 20th century. Us, Earth, our home from space. Maybe one of the other images is that one of that little piece of hardware that was sent off into space, and just as it was leaving the solar system, looked back and captured what Carl Sagan calls that pale blue dot, Earth. There we are in the midst of all of this, and it's the only place in all of the midst of those grand sparkling bits up there in the sky that is our home, where we can live and prosper and do whatever it is we do. And it's at risk, newly at risk, mostly in my lifetime, although the roots of our abuse of the natural world, mostly in ignorance, not knowing that we could alter the nature of nature, but now with evidence everywhere that we are putting everything we care about at risk. Shouldn't there be a law against that? Or maybe a lot of laws that protect our existence? We're still acting in a newborn way. But I think we've learned enough to know that we have to take care of the planet that takes care of us. Okay, so what makes Earth special? It's the water, first of all. All those great exobiologists, those NASA scientists who are looking for Earth, for life beyond Earth, what do they say they need to find? First and foremost, liquid, not just ice. There's a lot of water out there that's frozen in the solar system and beyond. But liquid water and ocean, we've got it. Lucky us. Mars doesn't have one, although it appears they might have had a sizable ocean once upon a time. The little moon of Jupiter, Europa, apparently has maybe water under a thick covering of ice that is not water. What do we know for sure? We know for sure that we're here, we're alive, that Earth is our home, and we can have now, as never before, tons of evidence that we are changing the underpinnings of what keeps us alive. Not until 1980 were there serious images of polar areas that show the clear evidence of how fast polar areas are changing. Now, scientists have known for a long time, and the public generally has access to this knowledge, that ice ages have come, ice ages have gone, Earth has come and gone, species have come and gone, the Earth has been warmer, it's been colder, there have been dinosaurs and then there were no dinosaurs, and so what's the big problem? Big problem is that yes, species come and go, yes, ice ages come and go and all that. We're looking out, should be looking out for how do we maintain a planet that works in our favor? How do we maintain the systems that make it possible for us to simply breathe the air, to be able to walk around? In much of the planet, actually, we can clothe ourselves and protect ourselves from the more or less hostile parts of the planet where it is really cold. We can create a cool atmosphere in really hot places through our technology. But all things considered, you don't want to have to walk around with a tank of air on your back. It's nice just to be able to take for granted, as we have throughout all of our history, a planet that is favorable to us. Anyway, that view of Earth from space has got to seriously jolt us into an awareness that we did not have, and it did. That view is credited with really shaking us up a bit and giving rise to some of those great laws that were talked about today. Clean air, clean water in this country. The Environmental Protection Agency was started as a consequence of the shock of our ability to alter the nature of nature. And globally, look at the changes that we have in a positive way about respecting the natural world. The national park system in this country came about early in the 20th century. Some say the best idea America ever had. Well, it's certainly a really good idea to proactively protect special places where there are big trees, lots of animals, homes for wildlife, for their sake, for their own sake, out of respect for them, but also for our benefit. Where do you think air comes from anyway? We did not know 1,000 years ago, 500 years ago. You know, it's taken a while just to know what air is. But now we know that it just doesn't happen as a physical phenomenon, it's a biological phenomenon. Thank goodness there is such a thing as photosynthesis, green things that generate oxygen while they're capturing carbon. I'm talking about trees, of course, and ferns and mosses, but also little guys, phytoplankton in the ocean, that generate more than half of the oxygen in the atmosphere, capture carbon as well, drive the great ocean food webs, the creatures that capture that energy, that carbon, as sugar that transforms into other food products. How do you make a whale? Well, you start with sunlight and phytoplankton, go up through the food chain, and then this large creature, think of what makes any one of us. Photosynthesis, green things that either we consume directly, all the plants that we consume, or indirectly through the animals that consume the plants, or even more indirectly, take a tuna fish that eats a fish that eats another fish that eats another fish, and so on down the food chain with thousands of pounds of plants making a single pound of tuna when we take it out of the ocean after it's grown there for a few years. We're all reliant on these natural processes. If you breathe, you should thank the ocean. The ocean is touching you when you take a breath. Now we know. What are we doing about our knowledge? So, third image I want you to think about is, there you are out in the open sea where phytoplankton prospers, where the food chain is just churning away, has been doing this for gazillions of years. And here we are, the beneficiaries of all that action. Oxygen going into the atmosphere. Take a breath. Thank you. Thank you, phytoplankton. Thank you, ocean. Thank you, carbon capture mechanisms that start with the green things but go right up the food chain. So we respect trees for carbon capture. We haven't yet quite gotten to the level of sophistication. We're almost there, thinking about, thank you, whales, for capturing and sequestering and holding the carbon that goes up the food chain. And there you are, this big carbon-based unit that ultimately sinks to the bottom of the ocean and keeps the carbon in the ocean. We take the whales out, or the tunas, or whatever else, the squid, the krill, the shrimp, the lobsters, whatever, we take it out. That carbon is released into the atmosphere, and the carbon capture mechanisms, like clear-cutting a forest, we're kind of clear-cutting the ocean and undermining carbon capture, oxygen generation, life support. Why? Well, mostly because we just haven't put the pieces together. There's still a lot of ignorance going around that can be cured. It's called knowing, listening to the evidence, observing. We're really good at gathering evidence and passing it along. That's why we're here, why we have glasses and tables and microphones and airplanes and light, because we've, over the centuries, over the millennia, we have learned from the past to inform ourselves and take us to the level of prosperity we now have. All right, you're out there in the open sea. Can you imagine? Some of you can. You've been out in the open sea. And I know Thompson, with his little crew out there in the open sea, no land in sight. You're just, just imagine that you're on a little tiny wooden vessel made of koa wood, special kind of tree. And you can see the Milky Way. You cannot see where you're going. You have to navigate by the stars. But that is just the surface. The average depth of the ocean is 2.5 miles, 4 kilometers, maximum 11 kilometers, 7 miles down. How many people have been up in the sky 7 miles, eating lunch, taking naps, looking at films, movies? I mean, we're talking many hundreds of millions of people have done that. Only 3 people have been 7 miles down to the deepest part of the ocean and come back. One-way trips are probably really easy. But the first one was in 1960, before General Anders took that picture of Earth from space. 2 guys in a little submarine went to the bottom of the Mariana Trench. There for only about half an hour, but they observed life all the way down, top to bottom, and verified what some suspected, but a lot thought was ridiculous, that there could be life in the complete darkness with 16,000 pounds of pressure down on every square inch of the deep ocean floor. But they confirmed that life is all the way, it's a living ocean, top to bottom, and confirmed then by James Cameron, who 52 years later went in a one-person system to the deepest part of the ocean and took pictures of the sea floor, the bottom of the Mariana Trench, little wormholes, sea cucumbers. Was there actually a flatfish, a flounder-like fish, as was observed back in 1960? I take the view that why not? Oxygen might be low, but then there are a lot of creatures who can get by with less oxygen than we, including some of the deep sea fish. So, all we know for sure is there's life there. We've also discovered with something called the Census of Marine Life, a 10-year project trying to figure out, okay, here is the world. We know quite a lot about insects, especially ants, but all of life on the terrestrial part of the planet. We've enumerated more than 9,000 kinds of birds. We've looked at freshwater, but okay, so let's evaluate who, what, where lives, what has lived in the ocean, what does live in the ocean, what might be in the ocean in the future. 10 years, Census of Marine Life. They came up with a figure that is far lower in terms of species that we now know about in the ocean than on the land, like 250,000, 250,000 that we know about that live in the ocean, 1.5 million that we know live on the land, mostly insects. But we've only looked at about 10% of the ocean. I mean, we've only seen about 10%, let alone really explored. We've only mapped about 10% of the ocean with the same precision that we have for the moon and Mars and Jupiter, and of course, the rest of our planet. But they did come away with the bottom line that the deeper we go, the less we know, but the more new discoveries we find. So there you are, out in the open sea. Imagine you're a turtle looking up and you see all those stars, or you're a sperm whale with the biggest brain on the planet. You are so intelligent. Sperm whales, we now know, have complicated language. We don't get what they're saying, but they certainly communicate among themselves with regional dialects, just as we have. You know, their version of French and Spanish and German and whatever. They're all humans, but they're all sperm whales, but they're all different populations around the planet. Well, they love to know what it was before we began annihilating them. They do not know, cannot know what a 10-year-old child today can know, but they're smart enough not to destroy the environment within which they live. I think that's real intelligence. Maybe we have some distance to go. I served on the International Whaling Commission for 4 years. I was the co-chair of I don't remember what I was. I was something. Deputy Commissioner, that's what I was, for the US on the International Whaling Commission during the time I was chief scientist at NOAA when they called me the Sturgeon General. I, was mystified because here are all these people saying that we've got all the constituents, the vested interests who care about whales together at the table. But we were determining the fate of the whales without them being at the table. I mean, in some countries, whales are on the table as part of the meal. And maybe, there's some long traditions that need to be respected, but we need to further respect that we're not alone on Earth in terms of the right to live there, and to respect the societies that have come up over the ages. There was just this morning an email message that I got that in the Clarion-Clipperton zone off Hawaii, where deep sea mining leases are being allowed, the deep sea where we have seen a fraction of what's there. We don't know who lives there, but they've found these depressions that are mysterious, hundreds of them in this area targeted for deep sea mining, that look, the best guesstimate, I guess, but it's more than a guess, the nearest thing that they found anywhere else that looks like these special depressions, hollowed out areas, not caused by waves or any other physical phenomenon that we can imagine, is they're made by whales. Made by whales, that's what we think, what is thought. The deep diving, maybe sperm whales, but maybe some of those toothed whales that are known, really mysterious animals that are related to sperm whales. They're not the baleen whales with those fuzzy mouthpieces that capture plankton, but this other family of whales with real teeth. And who knows exactly, but if it's true that whales make those newly discovered depressions, it would mean that these creatures can dive to the average depth of the ocean, about the depth where the Titanic rests, 2.5 miles, 4+ kilometers, 1,000 meters deeper than we think that marine mammals can go, holding their breath. There's so much we don't know, so much we need to know before we start to carve up the deep sea, carve up the high seas, the parts of the planet that no nation currently has claimed for their jurisdiction. And what do the whales think about us claiming parts of the ocean as ours? What about respecting something about the other creatures who, for long before there were humans, had already established these communities, these societies, these places that we have intruded ourselves? Can we not at least think about it and show some respect for them, knowing that it isn't just about the ethical or the moral considerations, it's about the selfish ones. What if we did kill all the whales? We came very close to killing most of the great whales in the 20th century, but we stopped. We decided, for reasons that were mostly moral and ethical, not back into our self-interest, but because we began to care about them. And now we know there are other reasons. Think about the carbon cycle in whales. Think about the carbon cycle and tuna, the carbon cycle, and all the creatures that live in the ocean that are the beneficiaries, as we are, as every form of oxygen-consuming life is. Photosynthesis. Ha! Glory be. Okay. So another image is to be that whale. Go down, whether it's only 1,000 meters or whether it's 2.5 miles beneath the ocean, 4,000 meters. Or imagine you're there at the deepest part of the ocean in one of those trenches that occur around the deep parts of the ocean. Most of them in the Pacific, but they're deep trenches in the Atlantic and in the Indian Oceans. I mean, it's dark. Even if you close your eyes right now, and I'm closing my eyes, I can still feel the light, I can see the light. But if you're in the deep sea, it is dark, except for the bioluminescent creatures that flash, sparkle, and glow of creatures that make their own living light. It's just hard for us to imagine where the world, that most of life on Earth, what it is like. We are air breathers, we're sunlight-dwelling creatures, but think of this, that sunlight penetrates the ocean maybe to as much 500 meters. You can catch a little bit of light a bit deeper than that. I have actually been off the coast of Hawaii, midday, sunlight, high noon. I was 400 meters down, and it's pretty dark, but I could still see up from down. I could see light above, and just enough light to see the shadow of outlines of corals that were growing in that dim light. But if I went another 400 meters, it would be really dark. Only bioluminescence would break the darkness. Most of life on Earth lives in the dark all of the time. That's a big statement, but think about it. 97% of the biosphere where life on Earth lives, it's out there in the ocean. Three-dimensional world, filled with life, top to bottom. It's where the action is. And we're only now beginning to sort of lift the lid and see how, not only how climate change is affecting the ocean, but how the ocean affects climate. And what we do to the ocean is affecting everything else. It's what we're putting into the ocean. Of course, excess carbon dioxide in the atmosphere is acidifying the ocean, changing the chemistry of the ocean. It's also what we're taking out of the ocean. All those whales we've extracted over the years, all those fish, hundreds of millions of tons. We've taken 90% of the sharks, just since, mostly since the 1980s, because of an appetite, a newly acquired appetite for shark fin soup and shark steak and macho meals and whatever. We're good at killing sharks. They're not very good at killing us, despite popular thoughts to the otherwise. Imagine, if you will, what Earth was like. Let's go back 5 million years. Humans were not around at all. There were sperm whales, there were cod, there were tuna, there were penguins in the Antarctic, there were polar bears in the Arctic. There are lots of things that we sort of take for granted that, yeah, they've always been here. Well, they were here before we got here, and some of them are still around. We've done a pretty good job at mowing down and diminishing the diversity of life on Earth on our watch, but we're the beneficiaries of all of the rest of life on Earth. Without them, we could not exist. Take away the phytoplankton, take away the trees. Imagine life on Earth, imagine Earth as it was 500 years ago. If General Anders had been up there in the sky 500 years ago, it would look pretty much the same as it does today. Or if Thompson were out there on the open sea 500 years ago, from the surface, it looks pretty much the same, except that now there is all this stuff in the water that didn't exist even 50 years ago, that we have become so fond of our single-use plastics, and you use it once, throw it away, and where does it go? Out there in the ocean. Well, it's still there. It will be there probably 500 years from now, unless we figure out how to extract it or stop the flow. Or you can take another image, imagine Earth as it will be 5 million years in the future. Well, that may be a stretch for our little pea brains to think about 5 million years in the future. 5,000 years in the future, well, maybe you're getting a little closer to what we can actually grasp. 500 years? How about 5 years? How about the next 10 years? What we're doing right now, you can look at what's happened in the last 50 years, the last 25, just look at the changes. Good news, bad news. and project forward at an accelerating pace. What can we do right now using our best, pardon the expression, judgment, all of us, not just if you're trained in the business of exercising good judgment, but what about the kids who are educating us as they learn and they can see a good thing that humans can do, project the future, armed with the knowledge, especially now. You can see what was. I mean, a kid can look at the past that his parents or her parents have experienced, and they wonder, where are we going? I mean, some of it's great, good news, all the technology that's taking us to new levels of prosperity in many ways, but at the same time, if you look and account for the cost, that's serious cause for concern. We're getting better at accounting for the cost. But imagine 50 years in the future. Some people in this room would be around 50 years from now and may hear the echoes of the kids of today saying, why didn't you do something you knew and there was time and you didn't do what was possible back early in the 20th century? What were you thinking? Or they might say, thank you, those of you who were around early in the 21st century. You saw the problems and you knew that you were running out of time and you looked at the solutions and you said, we've got to do whatever it takes. We've got to rethink the laws that were made during a time when we did not know what we now know. We've got the evidence. It's all around us. So how do we do it? I mean, I'm not able to give you an answer. I'm looking to you. The equivalent of the elders of humankind in an earlier age, when our communities were small and respect and judgment were vested in those who'd been around for a while, learned what to do to be safe, guidelines for behavior, the rights, the wrongs, the do's, the don'ts of society. You have magnified influence, magnified power to make the difference for everything that follows. I cannot tell you how to do it, but I do know that we have to protect the natural world as if our lives depend on it, because obviously they do. And we have some great examples of positive actions in the last century that are moving in the right direction, at least in some parts of the world. Another little tiny speck of real estate called Palau, a little island country, has a big exclusive economic zone owing to laws that humans have created to expand our territory out 200 nautical miles. I mean, Hawaii gives the United States a big boost in terms of territory because out 200 miles from this little speck in the Pacific, you have an outsized impact on the planet. Palau, likewise, they only have 20,000 people as a nation. Not, how many are in Vermont? 650,000, did I hear today? A lot more than Palau has. But here's this little country with a big voice and a big impact because the president, Tommy Rumingasau, decided to work with his people and come to a conclusion not long ago to protect 80% of their entire exclusive economic zone as a sort of gift to the future, a gift to the present. The fishermen can utilize the inner 20%, not willy-nilly, not just open season on all the fish, but by protecting 80%, they have a fair chance that there will be fish that they can extract for real needs, not for choices, not for luxury choices, but for consumption by the people who really are reliant on the ocean as a source of sustenance. A lot of what we take from the ocean today just goes to feed a luxury taste that is acquired in recent times. Think shark fin soup, think tuna, think sushi in Chicago, where tuna are far, far from Chicago, but we've acquired a love of munching on these wild things. Well, so the United Nations has come up with a recipe for action, 10% of the ocean for protection by 2020. That's only 2 years away. Where are we on the scale of blue parks that mirror the national park system that is managed over the years to secure about 14% of the land for proactive protection? Depends on how you count. If you count all of the areas that have some form of protection, we're at about 7% of the ocean with proactive, some form of real protection, where even the fish and lobsters are safe, where it isn't, some kinds of fishing are allowed. No, just full protection, like a really secure national park. It's just under 3%. Okay, 97% of the ocean is kind of up for grabs. And it's our life support system, where most of life on Earth actually lives. It's where most of the oxygen is generated, much of the carbon dioxide is captured, distributes temperature, really governs climate, governs weather, makes life on Earth possible. And so far, we've been able to secure 3 to 7% that we proactively say we care enough to say we're going to be really careful about what we take from this area or what we put into this area. The IUCN at a conference in Hawaii in 2016 suggested that we need 30% of the ocean by 2030. That's not that far away, and we're losing the battle fast just to keep intact some of the populations of creatures that we like to eat or that we know serve a really valuable purpose in terms of holding the planet steady. There are some who say nature needs half. Well, we need all of nature. The idea that we can destroy half and keep half alive, well, there's got to be something a little more respectful than that, I suppose. That we really need to respect all of the ocean. And yes, we will use land and sea. We will use the natural systems to secure our prosperity. But I think about the goal of the conference that the United Nations, nations around the world, came together in Rio in 2012, Rio plus 20. And the headline was, "What is the future we want?" Securing protected areas on the land and the sea is a good start. It's a necessary part of the equation, but we have to just understand what we are doing and what we should show respect for maintaining, not just individual places, but overarching policies like clean air, clean water, reducing carbon emissions. Overall, how do we manage ourselves so that those questions asked in the middle of this century by the kids of today will be answered, thank you for doing something, instead of why didn't you do something when you knew? Now we know, and as never before, and maybe as never again, we really do have a fighting chance to secure a long and enduring future for this species on a planet where maybe we're past the newborn stage, maybe we're in that adolescent phase where we think we know everything, and we still have a lot to learn. Thank you.
Thank you, Dr. Earle, for those inspiring remarks and for reminding us of all that beauty. As you were speaking, actually, my 10-year-old son, Andre, has been in the room listening very atento, I can't remember the word in English right now. And Justice Noor, who is sitting next to him, asked him, have you seen the Milky Way? And he responded, not so much, light pollution. So I wonder if we can make the kind of light that those creatures you mentioned make in those areas of the ocean. Because I think global change means that we all have to change as well. When I went to law school, judges were considered the last frontier, the last recourse that we had to address the challenges that we're seeing today. And today, the reality is that they are becoming the first line of defense in an area of the law that is really precautionary. So as we walk to the reception that we are having at the Art Museum of the Americas this evening, I would like us to remember the question that was posed this morning by our Secretary General. How would we feel if all that beauty that you highlighted because of all this change was not there anymore, so that we can continue our work tomorrow when we start? So kindly follow me, and we thank our colleagues that, well, they're actually already there, so we'll do that part over there. So please follow me to the museum. We will take these doors on the left. It says emergency exit, but there is no emergency. Thank you very much, and see you tomorrow morning for our next keynote.